So you say that you want shareholders. Well, class, here's a few things that you need to know. Welcome back. It's good to see you all again. Today we're going to address the shareholder element of corporate directors, officers, and shareholders. So, by way of quick review, we know that directors oversee the management of the corporation, officers execute the management and operations of the corporation, and then the shareholders, by contrast, are in the position of the owner of the corporation. And a shareholder is a bit has is a different creature from a partner, for example. Although they are a partner in the same sense that they're an owner in the same sense that a partner is an owner. They don't have any of the management or agency or any of the obligations that would attach to a partner with regard to duties. You don't have duties to fellow shareholders, for example. Your only interest as a shareholder is in the value that you gain from your equity, right? You're totally permitted to act in your self-interest, and there are limitations on what shareholders can do that are largely in tune with the amount of equity that the shareholder has, right? And then there are some legal constraints. For example, a majority shareholder can't simply oppress a group of minority shareholders. All right. So, with that in mind, we know that the acquisition of a share of stock makes you a shareholder, right? And a shareholder is an owner who is not a manager necessarily, and who won't necessarily have any type of connection to the company other than the fact that they own equity in the company, right? And the concept of share ownership is very interesting, especially as companies become larger or become publicly traded and are have other ways of interacting with the financial markets. For example, you can buy a share of Disney or Coca-Cola and hold it in your name, right, and be directly the owner of that share. But there are so many other ways that are much more common for people to hold their shares. For example, in a mutual fund or a 401k plan, it may, in fact, that share of Disney or Coca-Cola or whichever company you hold in your portfolio may, in fact, not be held directly by you. In fact, it won't be held directly by you at all. It'll be held by the mutual fund, and that mutual fund may have a nominee in whose name that share is actually registered, and there may be a chain that makes the actual ownership of that share. You're essentially a beneficiary of the ownership of that share, but who actually holds it might be far more complicated. And so this highlights one of the traditional features of this, especially of publicly traded equity, is its fungibility and the ability to use it almost in a way like currency. In fact, it is currency. It's a type of currency. It's not national currency. But to the extent that it's tied to the productiveness of a company, then it is very much like something that's fungible or that has a currency value. And this value is reflected in the value that you might see if you were to engage with the public markets in the purchase or sale of stock. Which brings me to the powers of stockholders and the reason that I bother to talk about who actually owns the stock in the first place. And then in the file that I downloaded for you guys, my notes, I note these powers, although they're of course all enumerated in the book. I'll go down and sort of talk about them in turn. They have the power to approve fundamental changes to the company, including articles, any changes to the articles of incorporation. For example, if you wanted to reform the corporation in another jurisdiction, that would need to be subject to shareholder approval. Any changes to the bylaws, significant major transactions, selling the company, buying a large entity might trigger that in some cases. Other major transactions, including bankruptcies, voluntary bankruptcies, of course. These are things that fall under the power of the shareholders to approve fundamental changes, right? Then they have the power to vote to approve directors or to remove directors, usually for cause, and in some jurisdictions, even without cause, right? The what's the difference? In Obviously, we know that directors are appointed to serve for a term, and the initial incorporator of a company appoints the first directors, and then they stand for election thereafter in front of the shareholders, generally annually. They may stagger. We'll talk about that later. They may stagger the election of the board, but generally elections are held annually, and we vote for a slate of directors, generally in an uncontested fashion, right? You don't generally remove a director, right? But when you do, it's generally for a reason. Now, cause, when we say the power to remove for cause, shareholders can remove a director for cause. That is a term that has, I'll call it a term of art. It's not necessarily defined in statutes that grant this power. However, it's commonly the type of term that would be defined in other documents that would govern the relationship between the director and that corporation. Cause, for example, may include such things as some type of corporate malfeasance or breach of trust, some particular action, right, or some conflict of interest that the director causes to arise. Those would be defined as quote unquote cause, or cause as a term of art for this purpose, right? But many states permit the active removal of a director other than at the close of their term with no cause whatsoever. And that has other interesting consequences, all right? So we'll just make a note. So we've got the power to approve fundamental changes, the power to vote to approve or to remove directors from office for cause or otherwise. They have a right to have annual shareholder meetings, right? At least annually. You can have scheduled meetings more than annually, and you can have special meetings whenever you'd like, right? You can have a special meeting or an emergency meeting, but shareholders all have a right to proper notice of emergency meetings. It's very important because the validity of corporate action that's taken may be subject to this rule. If it's not properly taken pursuant to a duly noticed shareholder meeting, anything that the company may have been trying to accomplish with that meeting might, in fact, be null and void, a nullity. Of course, they have the right to vote and the right to use proxies for one's own vote, meaning most people are not, especially in a huge corporation, not every shareholder of Coca-Cola is going to show up in Atlanta or wherever they decide to have the shareholder meeting to vote on matters that are put before the company, right? But you can have someone vote your shares for you, and that's called the using of your proxy to vote those shares. Along with that, you have the right as a shareholder to solicit the proxies of other shareholders so that they can be used to support policies that you support. Which brings us to another power, and that is the power to actually propose policy changes. The power to propose policy changes. And I'll just bring up this slide here. You guys have all this, but I just wanted to show it to you. SEC regulation 14A8 for registered companies with any shareholder who has greater than $1,000 value in stock ownership, and that's going to be on the record date for whenever the proxies are sent out or noticed, the meeting is noticed. Any person who has that meets that $1,000 threshold has the right to have their proposals for included for consideration in the corporate proxy materials, right? So that also has interesting implications that I hope to discuss shortly. So the corporate resolutions that are adopted are basically the result of these shareholder votes. And resolutions, resolved, right? Resolutions, basically presentations of business matters for official action to shareholders, right? So you'll take a look at that little flyer there. I did up, obviously, great use of my time. One vote per share, right? So you think of it as almost like one man, one vote, except for no, the people are the shares, right? One vote per share. However, right, you can limit voting by having different classes of shares, right? What does it mean to have different classes of shares? An example that I'm familiar with, the Bancroft family once controlled the Wall Street Journal. They were the determining factor in the sale of that company and Dow Jones to Rupert Murdoch. And even though they only owned, I think, less than 30% of the equity of the company, their shares were in one class, say called Class A, and their shares had more voting power than the shares of that were circulating among the general public, right? And so, which we'll call Class B shares, right? And so, even though all of these Class B shareholders were very excited to get Rupert Murdoch's offer, it wasn't until he was actually able to convince the Bancroft family to vote in favor of the merger that they were able to actually complete that transaction and sell the Wall Street Journal. Now, imagine what it must be like to own only a few shares of the Wall Street Journal and be subject to essentially the decisions of other private holders of Wall Street Journal shares. Even though their family had been connected with the Wall Street Journal for generations, they were shareholders like anyone else. It creates a bit of a discussion about the value of different classes, having different classes of shares, right? It's basically a control mechanism that's used by generally those who've either invested a significant amount in a company to secure its acquisition, or have otherwise kind of come into control of the company, and they want to structure the company in a way that allows them to maintain control. All right. So with that in mind, take a look at these at the prompt below, and please respond regarding the powers of shareholders. All right. Thank you very much.